Welcome back, everybody. I'm Ryan Keeney, and today we're going to be talking about the question, can you get a search warrant in civil court in Ontario? To be clear, this question is not about criminal investigations that the police perform. This is for civil lawsuits, usually involving disputes regarding property, money, contracts, and that kind of thing. Now, we're going to go into a fair bit of detail here. So if you're watching this video on YouTube, I've placed timestamps in the description so you can jump ahead to a particular part of the video if you need to. But if you are new to this stuff, I do recommend watching the video from start to finish. Also, I'm pretty sure that Facebook doesn't have a timestamp feature. So if you're watching this video on Facebook, you unfortunately won't be able to see the timestamps in the description. So can you get a search warrant in civil court in Ontario? Well, the short answer is yes, you can, but it's not going to be quite like the search warrants that police use. There are some big differences, so let's keep that in mind right from the beginning. A major difference between a civil search warrant and a police search warrant is that a civil search warrant doesn't empower you to use any kind of force. That means you're not going to be kicking down any doors or forcibly subduing somebody while you're performing the search. Only the police can do that kind of thing. We'll get into how civil search warrants can be enforced if people are being uncooperative, but we have to talk about the basics first. First, I should mention that you can't get a civil search warrant in small claims court in Ontario. So rather than hiring a paralegal, you'll be hiring a lawyer and the case is going to be heard in Superior Court. Like I mentioned in one of my previous videos, the small claims court is technically a branch of the Superior Court, but they're treated as very different places with different kinds of judges at each place. But one of the main differences that's relevant to this video is you can't get a civil search warrant in small claims court from a deputy judge, which is what judges are called in small claims court. And you can't even get them from a master, which is another kind of judge that you find in Superior Court. You actually have to get these kinds of court orders from a justice of the Superior Court. That's a higher level judge than the other ones I mentioned. Who knew judges could have so many different names in Ontario? Okay, let's talk about why you would want to get a search warrant in the context of a civil lawsuit in Ontario. Well, one possibility is if you think that there's a serious risk that the person on the other side of the lawsuit or the company on the other side of the lawsuit is going to destroy evidence. You're obviously going to want to do anything you can to preserve that evidence. Now, there might be less serious situations where you don't actually believe that the other side is going to destroy any evidence, but you would still like to preserve that relevant, important evidence that's not in your possession that maybe someone else is holding. There's a few legal tools available to solve situations like this, and in this video we're going to be talking about two big ones. The first is called a Rule 45 preservation order, and the second tool is a little bit more extreme, and it's called an Anton pillar order. I know that sounds like a bit of legal jargon, but don't worry. I've made sure that the information presented in this video is as plain language as possible, so even if you're a law student or an articling student, a junior lawyer, or someone who's never been to law school, you should still come away with a basic understanding of how these legal tools work. Let's start with the Rule 45 preservation orders, and then we'll talk about Anton pillar orders after that. It's kind of hard to talk about one without talking about the other in one video because both of these types of court orders are very similar to each other. They're often confused with one another. They both authorize entry into somebody's premises for the purpose of preserving evidence, but there are some important differences, which is why they have two different names and two different legal processes when you actually get in front of a judge. Regardless of whether we're talking about a Rule 45 preservation order or an Anton pillar order, either of these types of court orders can interfere with a defendant's rights and their freedom to deal with their own assets. So for that reason, the court will generally only grant these kinds of court orders in exceptional and limited circumstances. These court orders are not meant to be taken lightly. So with a Rule 45 order, you're basically going to be asking a judge to issue a court order against someone who may or may not even be involved in the lawsuit. So in other words, they may be a party or a non-party. And the Rule 45 order can accomplish a lot of things, such as the following: prevent the defendant from removing physical assets that the plaintiff claims ownership over. And of course, that ownership will be decided by the end of the lawsuit. Preserving shares in a corporation that are at risk of being canceled or otherwise disposed of. The order can require people to preserve electronic information, electronic data that they might be in possession of, and not delete that data. Preventing the destruction of a device containing important electronic data as well, which is a slight distinction. Or require the preservation of a certain amount of money that's sitting in an account somewhere until the lawsuit is complete. Or the return of collateral held as security for a debt. Okay, now just because you ask a judge for a Rule 45 preservation order doesn't mean that you're automatically going to get one. In my last video, I talked about how lawyers use the word test or meeting the test whenever you have to prove a predefined list of requirements before the judge will grant you something. So in this case, the test for a Rule 45 preservation order has 4 parts to it. Before I get into what those 4 parts are, there's 2 quick legal terms you need to know about. 1, the meeting you have with the judge when you're asking for that court order is called a motion. And 2, the party that's asking for the court order is called the moving party. Okay, with those 2 definitions out of the way, here's the 4 parts of the test. The first part of the test is the moving party party has to show the judge that the evidence that they're trying to preserve is basically the subject matter of the lawsuit, or it's somehow related to the lawsuit in some way. But if you can't show what that evidence has to do with the case that you have against the defendant, you're going to be having some trouble right at the first part of the test. The second part of the test is similar to the first, but it sets the bar a little bit higher. You have to show the judge that there is a serious issue to be tried. Now, I know that the phrase serious issue to be tried is not something that most of us use in everyday speech unless you're a lawyer, so I'll explain what that means. A serious issue to be tried basically means that when your case eventually gets to trial, there's going to be a serious question of law or legal issue that the judge at the trial has to deal with, which involves that piece of evidence that you're trying to preserve. So as you can imagine, if that evidence isn't preserved, it's going to make the trial judge's job a little bit harder, and it could impact the integrity of the trial. Okay, so the third part of the test has less to do with the trial and more to do with the sort of general ability of the people involved in the lawsuit to either advance their lawsuit if you're the plaintiff or defend the lawsuit if you're a defendant. You have to show the judge that if you don't take possession of this evidence or if it's not preserved in some other way, you might run into some trouble actually being able to take your case through the courts and actually build your case all the way up to trial. This makes sense because there's a lot more to a lawsuit than just the trial. And if important evidence gets lost or destroyed along the way, then it will jeopardize the entire legal process. Okay, so the fourth and final part of the test for getting a Rule 45 preservation order is a bit more complicated in the way it's worded, but it basically says this: the moving party has to show that the balance of convenience favors the moving party. If you watched my other video about Mareva injunctions, you might have heard me already talk about what the phrase balance of convenience means, but I'll explain it again in this video. It's easiest to think of it like this. When you're asking the judge for a court order, there's only two possible outcomes. The judge is either going to give you the court order or the judge is not going to give you the court order. So the balance of convenience is asking the question, who would suffer the greater harm in each of these two outcomes? So for example, if the judge says, no, we're not going to do anything to preserve this evidence, and the harm caused to the plaintiff by doing that is like a 9 out of 10. But on the other hand, if the judge says, yes, we're going to issue this preservation order and we're going to require the defendant to preserve this evidence, and the inconvenience and the harm done to the defendant is like a 2 out of 10, then as far as that part of the test goes, the judge will probably want to issue that court order. I know that might sound like an oversimplification, but it's just meant to explain what the phrase balance of convenience means. It's important to keep in mind that there's a slightly different test that applies when you're trying to preserve a specific fund of money compared to other types of evidence. You might remember that one of the things I mentioned earlier is that a Rule 45 preservation order can require that a specific sum of money sitting in an account somewhere be preserved. Well, when it comes to doing that, there are 4 things that you have to show the judge again, but those 4 things are slightly different. Some of them are the same and some of them are not. 1, you have to show the judge that there exists a identifiable amount of money sitting somewhere at the time that you're asking for the court order. 2, the plaintiff has to show the judge that they are claiming some kind of ownership in that amount of money, which has been stated in their lawsuit as part of their legal case. The third part of the test is the same as what I mentioned a moment ago. You have to show that there's a serious issue to be tried. And I'm not going to waste your time explaining that again. If you need to listen to that explanation again, you can just go back to that part of the video. And the fourth part of the test is also the same. It has to do with the balance of convenience question that I mentioned a moment ago. So as you can see, it's not that different between trying to preserve money and trying to preserve other kinds of evidence, but it is worth noting that there's a slight distinction in those two types of Rule 45 preservation orders. The last thing I want to mention about Rule 45 court orders is that it's really important for lawyers and clients to consider a few things before they bring this kind of motion. First, you have to ask yourself, is my Rule 45 motion actually going to get me what I need? Is it going to accomplish what I'm trying to accomplish? Or is there some other kind of motion that would be more appropriate, like a Mareva injunction, which I talked about in a previous video? Second, you and your lawyer should try to anticipate in advance if you can even meet the test for a Rule 45 preservation order. That's the 4 parts I was describing a moment ago. I mean, if you bring your motion in front of a judge and you're not in a position to be able to prove those parts of the test, and you fail to meet the criteria of getting a Rule 45 order, not only will you lose your motion, you'll probably have to pay some money to the other side for the legal costs that they incurred defending the motion that you brought against them. Another thing to consider before you shoot first and ask questions later when it comes to Rule 45 orders is whether or not you can just negotiate some kind of deal with the other party, if you can come to some kind of agreement without having to take the issue in front of a judge. I get that a lot of lawyers can be unnecessarily uncooperative and it's not always easy to come to an agreement, even though it's obvious to everyone that just negotiating the issue could save everyone a lot of time and expense. If you are dealing with that kind of lawyer on the other side of the case, the best thing to do is just to show the judge copies of your email correspondence between your lawyer and that lawyer, so you can show the judge that you tried to resolve this issue in a reasonable way before actually having to bring bring a motion in court. Judges usually don't like it when lawyers create unnecessary costs and undue delays, so the other side might end up having to pay you some money for their behavior. It's always good to have proof that you were the more reasonable one in the lawsuit. Okay, so we still have a lot to get into about the next related topic, which is Anton pillar orders. Like I mentioned before, Anton pillar orders are a little bit more serious and a little bit more extreme than Rule 45 preservation orders, and they're intended for situations where the applicant legitimately fears that the other party is going to destroy evidence and more serious action is required, usually on a short deadline with some urgency. Right off the bat here, one of the major differences between Anton pillar orders and Rule 45 preservation orders is that Anton pillar orders are usually filed in court before the plaintiff even officially starts their lawsuit, before they even file what's known as a statement of claim outlining their case against the defendant. It's at a very early stage. And not only that, it's done on what lawyers call an ex parte basis, which in plain English just basically means you're meeting with the judge without the defendant or their lawyers even being there or knowing about it. Now, that might seem a little bit unfair against the people that you're getting this search warrant against, but you have to remember that we're talking about situations where there's a genuine concern that the evidence is going to be destroyed, that you think that there's going to be some serious wrongdoing concerning the evidence in the case. There's some very simple logic here. If you give someone advance notice that you're trying to get a search warrant against them for the purposes of a civil lawsuit, that will only motivate them to destroy the evidence even faster. That obviously wouldn't make a lot of sense. So there are very logical legal reasons why the justice system allows you to get this kind of court order without any advance notice to the defendant. Just like we spent some time talking about the test for the Rule 45 order, there's a 5-part test for getting an Anton pillar order, and we're going to jump into that now. First, the plaintiff has to demonstrate what's called a strong prima facie case. So what does that mean in plain English? Prima facie is just a fancy legal term for at first glance or at first impression. So lawyers use that term to describe situations where at first glance on the surface of things, it looks like a certain party has a really strong case until the defendant has an opportunity to present their own evidence and rebut that case. Basically just asking, does this case have some strength to it? Does it have some merit to it? Is there anything to this case? We don't need to decide the whole case right now, but on the surface, does it look like the plaintiff has some kind of case here? Okay, so the second part of the test has to do with the damage that will be done to the plaintiff if that evidence was lost or destroyed. You have to show that that damage will be very serious, and it could include damage that's already been incurred or is going to occur. But what exactly do we mean by damage? The way this word is used here can sound a little bit confusing in a legal context. There have been two common ways that we talk about the damage that could be incurred from the evidence being destroyed or lost. The first is what's called the procedural impact. That has to do with the way the case moves its way through the court. The court will ask the question, what is the potential procedural consequences of not preserving this evidence? How would that affect the integrity of the legal process? The second way of interpreting the word damage has to do with the applicant's financial health or their reputational health or similar things about the plaintiff's well-being. This could be a loss of revenue to their business or a loss of their personal or professional reputation. So if you can show that there is some kind of damage that's going to happen here, which is very serious, then you'll have satisfied this part of the test. Okay, so the third part of the test to get an Anton pillar order is you have to show the judge that there is convincing evidence that the party you're trying to get the court order against actually possesses some kind of incriminating documents or other evidence. Now, here's an interesting point about this. If the evidence you're trying to seize has already been leaked to the public, then you're probably not going to get your Anton pillar order, because even if the defendant or that party, whoever you're trying to get this court order against, destroys the evidence that's in their possession, well, you could just get a copy of it from the public domain, wherever it's been uploaded online. The fourth part of the test requires the applicant to demonstrate to the judge that there's a real possibility that the evidence is going to be destroyed before the discovery process. Now, I know I haven't mentioned what the discovery process is yet, so I'm going to spend a moment to explain that to you. If you think back to your favorite TV legal drama, whatever show that might be, you've probably watched a scene where some lawyers and witnesses are sitting around a conference table, not usually in a courtroom, and the lawyer is just asking all these tough questions to the witness with a camera in their face, and there's usually someone sitting there with a computer typing out their answers. Now, in America, they call that a deposition, and in Canada, we like to call that examination for discovery. That is the process that lawyers use to obtain evidence and testimony from people involved in lawsuits before you get to trial. But it can take a long time to get to discovery, and in that time frame, some people might try to destroy evidence. There's a lot of people out there that wouldn't care that doing something like that is totally illegal. So now that you know what the discovery process is, I'm going to get back to this fourth part of the Anton pillar test. It's really just showing the judge that if you were to try to gather this evidence in the usual process, there's a real possibility that the evidence is not even going to exist, or it's going to have been destroyed by the time you get to that stage of the lawsuit. So that creates some urgency for getting this search warrant to seize the evidence at a very early stage by surprise, before anyone has a chance to destroy it. Okay, so the fifth and final part of getting an Anton Pillar search warrant is the one that gives applicants the most goosebumps and makes them the most uncomfortable. The applicant basically has to swear under oath that they will pay compensation to the other party that they're getting this court order against if it turns out that the Anton Pillar order was not warranted and the other party sustained some kind of harm because of it. This is called an undertaking as to damages. That's just the legal name for it, and it's something that I mentioned in my video about Moreva injunctions as well. So as you can imagine, this is a bit of a gamble for the applicant. Sure, the applicant might get this wonderful search warrant where they can perform this search and seizure of property and preserve evidence, but let's say that the party that had the search warrant executed against them convinces a judge later on down the road that it wasn't necessary and that they incurred a lot of harm because of it. That situation could really end up backfiring financially for the applicant who got that search warrant. So basically, my point in clarifying this is if you're going to ask your lawyer to get an Anton Pillar order, you and your lawyer should be very confident that it is warranted, because you can end up experiencing a lot of bad financial consequences if you bring overly aggressive Anton Pillar orders that shouldn't have been filed in court. So when you get your Anton Pillar order, you're actually going to be assembling something called a search party, which, if I'm being honest, sounds really cool. The court will specify who the members of the search party are going to be, and it'll actually be written right there in the court order. So typically the members of the search party will be at least one lawyer and sometimes a law student and other staff from the law firm representing the applicant. It will also specify whether or not the applicant personally, which is that lawyer's client, will be allowed to be a member of the search party and participate in the search. And the court order will also specify whether any experts will be participating in the search and seizure of whatever premises was ordered to be searched. So this could include forensic accountants, it could include computer specialists, professional engineers, private investigators, basically any expert that the court is convinced needs to be participating in the search. Now, the Anton Pillar order will allow the applicant to take and preserve evidence, but the applicant will typically not be granted custody of that evidence. Instead, and this is a very important point, an independent supervising solicitor will be appointed. This person is usually called the ISS. This isn't a government agency or anything like that. The ISS is a lawyer that's hired by the applicant to supervise the search, and that lawyer cannot be affiliated with either party in the lawsuit, any of the parties in the lawsuit, because that lawyer needs to remain relatively unbiased and preserve the integrity of the legal process. Whereas the lawyers representing the applicant or the respondent, plaintiff, defendant, their job is to be biased in favor of those parties. That's also part of the process. By the way, the ISS role can be shared by multiple people, so you can have large groups of ISS lawyers for larger searches or bigger cases that require that kind of thing. So even before your motion to get an Anton Pillar order, you should actually be looking for candidates that are suitable for the role of being the ISS, seeing if there are any conflicts of interest or any other reasons why a particular ISS candidate cannot fulfill that function for your case. It's interesting because even though the applicant is the one looking for ISS candidates and selecting a candidate and paying that candidate, just because the applicant is paying the ISS doesn't necessarily mean that the ISS owes any special loyalty to the applicant. The ISS will basically discharge their duties under the court order and carry out the functions that the court required them to carry out. When you do find an ISS that's suitable for the role, their name should be included on the court order. Now here's a quick list of what the ISS actually does and who they must be. First, the ISS must be what's known as an officer of the court. So that basically means they're a lawyer. Second, they make sure that the search and seizure process does not go beyond what is actually stated in the court order and that nobody's overstepping their bounds. Third, the ISS has to make sure that certain people do not view documents that they're not entitled to see. This could include private communications between the defendant and their own lawyer. That's a special kind of confidentiality that we call solicitor-client privilege. Even though the applicant is performing a search and seizure of the defendant's premises, there's obviously going to be some stuff in there that the applicant shouldn't legally be allowed to see, and that will go to the ISS, like pretty much all of the other evidence that's collected. And then the ISS will screen that material to see what is and is not protected by solicitor-client confidentiality or some other form of special confidentiality. Fourth, the ISS must be present at the premises during the search and seizure process. And fifth, which is very similar to what I said at number 3, the ISS is responsible for taking custody of evidence, even when the ownership of that evidence is sort of in dispute, when you don't really know who owns a particular piece of evidence that's being seized. The ISS will basically hold it on a temporary basis and might even release some of the evidence to expert witnesses, such as forensic investigators, to study the evidence and draw conclusions. So not only is the ISS taking the evidence, they're also going to be managing it for some time during the lifetime of the lawsuit. So like I mentioned earlier, in both an Anton Pillar order and a Rule 45 preservation order, it's not like the search warrants that the police get, so you don't have the power to knock down any doors or use any kind of force, like I mentioned. So that raises the obvious question, what do you do if you get an Anton Pillar order or even a Rule 45 order allowing you to search a particular premises and you are not granted entry, or someone tries to interfere with the search in some other way? If that happens, you're going to have to ask your lawyer to file a motion in court called a contempt motion. If a person is found in contempt of court, they might have to spend some time in jail, so the threat of going to jail is usually usually enough for people to comply with the civil search order. Now, convincing a judge that someone is in contempt of court is not exactly easy, and it's not something that the court will do very often. You basically have to show the judge three things. First, you have to show the judge the court order that you're saying was breached by somebody, and that court order has to spell out exactly what should and should not happen so that the duties and obligations of the people that the court order was made against is very clear. Second, you have to show that the person that you're accusing of being in contempt of court had actual knowledge of what was in that original court order. And the third thing is you have to show that the party that you're alleging breached that court order intentionally acted against what that court order said, or they intentionally failed to do something that the court order told them to do. That's what lawyers call an intentional act or omission. And you have to prove all this beyond a reasonable doubt. Even though this is a civil lawsuit, you start getting into sort of criminal law or what we call quasi-criminal law territory. So in the context of an Anton pillar order, people have been found in contempt of court by refusing the search party entry into the premises or otherwise interfering with the meaningful conduct of the search. Now, there's a lot more that I could say about civil search warrants in Ontario, but now you've got a basic understanding of how they work. Remember, this video is not intended as legal advice. That's it for today. As always, send me your questions and I'll be happy to answer them. I'm Ryan Keeney, and don't forget to like on Facebook and subscribe on YouTube. I'll see you next time.